Well, hi everybody. Welcome to Active Self-Protection Extra. I had a really interesting question asked of me about the difference between legal self-defense and moral self-defense. It came in the way of actually a legal challenge to some other stuff that we're doing as an expert witness, but I want to talk to you today about, is there a difference between legal use of force and moral use of force?
Today's video is brought to us by Mantis. The Mantis family of products is integral to ASP staff building handgun and carbine skills and are your most economical and fastest path to improvement in your skills too. Whether you choose the X10, the Laser Academy, the Blackbeard, or use them all in concert, they will help your practice be more effective, efficient, and fun. Go check them out, pick up a unit, and thank them for sponsoring today's video.
So I think this is an interesting question and probably one that maybe I can answer better than a whole lot of people, It was recently pointed out to me that, oh, okay, well, John, you have an advanced degree in religion and you were a vocational pastor for 14 years and you've authored 2 theology books and you teach moral use of force on the channel. You teach people to be a good, sane, sober, moral, prudent person. And that's a different standard than the law. And so you don't teach the law, you teach a different standard. It's a moral standard. Okay, well, let's talk about that a little bit. And I think there is an interesting discussion to be had about the difference between moral and legal use of force. Because the answer is, on the big channel and here on Active Self-Protection Extra, we actually teach both, all right? We teach moral use of force and legal use of force, and let's talk about, are they the same? The answer here, TLDR version, yes and no. I'm going to get very lawyer-like and say, it depends. Well, there are some distinctions between moral use of force and legal use of force, but really in the realm of self-defense in particular and the use of force in particular, the overlap between moral and legal is almost a circle. It's not quite a circle. There are some distinctives, but they're very few. And let's talk about that because we do call people on the channel to a higher standard than the legal standard. That's just like as a firearms instructor, when I'm doing firearms instruction, I call people to a higher standard than the qualification. I say, wait a minute, if you're going to be a carrier of a firearm as a private citizen, you should absolutely be able on demand to pass the FBI shooting pistol qualification. Are you required to do that? No, that's not a legal standard anywhere in the nation to carry a concealed firearm on your person. There are a few states that have a live fire, requirement for their CCW, but they're nowhere near the standard of the FBI qual. And so I say, listen, you should take it on yourself to hold to that standard, and I certainly hold myself to that standard, but it's not a legal requirement to do so, but I call you to do so. And then, of course, if I was called to testify in court and somebody says, well, Mr. Curry, you teach people to do that. Yes, that's our best practice, but that's not the legal standard. That's not the legal requirement. There's a difference between best practice and maybe the moral equivalent and the legal standard. Let's think about this in other arenas, not use of force. Are there laws that are wrong because they are, or are there laws where it's wrong because we say so? So this is a legal concept, right? So this legal concept is, I'm going to use some big Latin words. Ready? There's a difference between malum prohibitum and malum in se. So there are rules, laws that are malum prohibitum, and the word malum means wrong. And prohibitum means because prohibited. So something is malum prohibitum when it is wrong because it is prohibited. You might think of something like, well, you have a speed limit of a certain miles per hour on this road, and that's going faster than that is wrong because we say so, and because we've decided that's as fast as we want you to go. Now, you could dig underneath that and say, well, we've determined what a safe and prudent speed is here, and going faster than that endangers people. But does it really? Probably not. We could say something like, here's one adjacent to use of force, but not really. It is against the law for a private citizen to carry a firearm into a court. Why? Because we say so, because we made a law against it. Now you might say, well, there's some underlying dangers from that we worry about people coming in and shooting up the court. Well, if they're going to come in and shoot up the court, they could probably shoot up the guards at the front of the court and get a hold of those guys and win that fight pretty fast and then get in court too. But at the bottom line, it's wrong because we say so, not because it's wrong in and of itself. Whereas in the use of force realm, something that is malum in se is wrong by itself, wrong in and of itself. In se means of itself. So what's something that's malum in se? Well, we say that things like murder is wrong, not because we've made it illegal. We've made it illegal because it's wrong. So it is wrong in and of itself to take the life of another because, again, the founding documents of our country, right, is that we hold these truths to be self-evident, that all men are created equal and are endowed by their creator with certain inalienable rights, among them life, liberty, and the pursuit of happiness. And so that right to life is gifted in the minds of the founding fathers by our creator, and therefore to take it is wrong in and of itself without some significant justification. So we make that a law that says, hey, we recognize that that is wrong in and of itself, and so we have a law that has an underpinning moral backing to it that says that that is wrong in and of itself. And as a general rule, 3,500 years of Western civilization, right? So we can say, I would say, Western civ goes back to at least probably the 10 Commandments. 3,500-ish years ago. We can get into some arguments, 3,300 years ago. Let's just call 3,500 years ago at this point. And say, okay, so from that point forward, we have the foundation of Western law, which says you shall not murder because of the great value and worth of the human being. So that is wrong, right? What are some other ways that we could see something is wrong? As a general rule, as Americans, we adopt a libertarian perspective that we say that I love the words of Tim Cotton, who was the communications sergeant at Bangor, Maine Police Department for a long time, great social media guy. And he said, be kind to one another, keep your hands to yourself and leave other people's things alone, right? So taking someone else's stuff is wrong because it's not yours. And so it is wrong in and of itself to steal. And therefore we've made that illegal. So there is a malum in se. So there's a difference between malum prohibitum and malum in se. So from a legal perspective, we say, wait a minute, in the use of force, all of the use of force laws are built on malum in se crimes. They're built on a crime that is wrong in and of itself, that our legal system recognizes that. Outside of that, some yes, some no, right? There are some things that are not moral or immoral. They're amoral, but we decide here's where we want to set the boundaries, and therefore you can obey or not based on whether or not you're willing to pay for that problem. Is there a time for malum prohibitum laws to ignore them? Yes, there are times to do that. But you got to be cautious and be ready to pay the price for that. For instance, if we go back to driving, right? You could imagine, and I've actually had this, where I had a loved one having a medical emergency and I had to get them in the car and get them to medical care. And we didn't have time to wait for an ambulance. And so I hauled butt and I broke all of the speed regulations on the way there. I was ignoring the laws. Now, I could have been pulled over, could have been written a ticket, but it wasn't immoral for me to be speeding, right? It was actually a moral good because someone's life was at stake. So I had to be doing that. The preservation of life is a higher standard than following the law. So I had to do that, and I felt morally quite clean to do so. I didn't get a ticket. Everything was fine there. Here's another, for instance. Sometimes people think, oh, wait a minute, what does it mean? If there's a fire truck behind you and you're at the light and the fire truck can't go around you, and they are honking at you with their lights on and siren going, waiting, they will need you to move for them to get past you in order to get to somebody who's having an emergency. And you go, aha, it's legal for me to run this red light so that they have space. No, it's not. It's actually not legal. There's nothing that I'm aware of in any state, certainly not in mine, that says it's legal or required to run a red light for an emergency vehicle. I've even seen people who've been ticketed for that. Now, you would certainly think that hopefully an officer would have some understanding if you could do so in a safe manner to break that law and with necessity and means. And you could maybe even take that to court and say, Your Honor, as a necessity defense, I had to in order to get out of the way of the emergency vehicle who was heading somewhere on a true emergency, and I did so in a safe manner, so I followed the intent of the law, that red light is to keep me from hitting somebody else who's going the other way. I waited till there was nobody going the other way, so it was safe for me to go. I went through. So yes, I technically broke the law, but I didn't break the spirit of the law. And I ask you to just dismiss this. A judge might dismiss it, but they might not. I think personally, if it's safe to do so, I think it's quite moral to get out of the way of an emergency vehicle, but it is illegal to go through that light, okay? So now let's take that into the legal realm. Well, here at Active Self-Protection, we do call people to be good, sane, sober, moral, prudent people. That's our teaching message here at ASP. If the legal standard is here, we call our followers, we call ourselves first and foremost, to a very high standard, not just, this is why, like, for instance, when somebody's like, well, John, can I shoot someone if? And I always say, never ask, can I shoot someone? Always ask, must I shoot someone? Because if I must, I'm probably going to meet this legal standard, which is usually lower than that, and I will be okay. But if I ask, can I, and I go, yeah, probably, I might end up getting charged here, I might end up getting convicted here. So recognize that. When you say, aha, my state says I can do that, maybe your state does. And there are some differences in state laws on use of force, and even some differences in jurisdictions. Not every state in use of force laws or firearms laws has statewide preemption. So some cities and municipalities, counties can set their more restrictive rules. I'm thinking of things like, as a general rule throughout the land, using deadly force to protect property is illegal. There is one provision in Texas law, Texas Penal Code 9.32, that does allow, in some very limited circumstances, the use of deadly force to protect property at night. And so there's some limited application of that. That is a place where the state standard, the legal standard, is different in Texas than it is in other states. And it's a pretty unique statute. That's like, for instance, I think, as far as I understand, the state of Florida is the only state that a warning shot is legal in. So Florida had a particular case where a woman in a domestic situation fired a warning shot at her ex-husband, who she was worried might attack her, and fired one into a safe direction, ended up getting charged for that. They changed the law in Florida in particular to allow the use of a warning shot. Anywhere else, you're going to get charged for that. That is going to be illegal. And so, okay, there are some differences, right? And we do teach both. So we want folks to understand, every week on John's Briefs, we talk here about the legal standards. Here's the legal standard that you're going to be held to. So make sure that you at the very least follow this. And then on the big channel, we'll talk about, okay, here's the legal standard, but here's a standard of best practice. Here's the standard that we want you to really think about and hold to, so then that way you are ready and capable of defending yourself well, and not only win the fight, but win the fight after the fight. So this is why we talk about living a lifestyle of de-escalation, escape, and evasion. This is why we talk about not getting yourself into unnecessary conflicts. Even in states that have something like a stand your ground law, which the majority of states do. I believe 36 states have stand your ground laws right now, and 14 states still impose a duty to retreat outside the home. And, so some people, there's some different standards here legally. Although the funny part is what we say is, from a practical perspective on duty to retreat and stand your ground, they're functionally almost identical, and you won't really see a significant difference between them in practical application. Okay, so is there a difference? Well, there's a huge amount of overlap between moral use of force and legal use of force here. And if you conduct yourself in a manner that comports with 3,500 years of Western civilization and the morality therein, which is at its core derived from the Judeo-Christian ethic of love for neighbor, is where that is. So there is, again, 3,500 years of love for a neighbor. And whether you're getting out of Leviticus or out of the words of Jesus, whether you've divorced it from that and said, well, we don't need those words in order to continue to have that because it's just kind of self-evident good in the universe, okay. That's where it at least came from in these fine United States. And I'm not saying other religions don't have that too. Let's not get into a flame war here. Just saying where it came from in terms of English common law that then built its way into American jurisprudence. And so we want that love for neighbor to shine through, right? We want to be the good people. We want to be the best and upstanding citizens, the highest and most virtuous, right? That's to me the standard of what we want to aspire to be the best in our communities, to love people really, really well, to be a force for good. and those things. So we teach that very high standard of moral use of force. Though, of course, when it comes down to it, we say, well, wait a minute. Well, this is the legal standard by which you'll be judged by the court. And you want to make sure that you're at least above this, that if you're not above that, this is this legal standard. So we say all the time, you don't have a duty to retreat, maybe. Maybe, he doesn't have a duty to retreat, so he's not required legally to do that. Morally, we may feel like that was a better answer, or tactically, that may be a better answer, but he doesn't have to do that, and therefore, that's not an issue here from a legal perspective. There's other things, like I don't think this is a moral issue, it's a tactical issue, but open carry versus concealed carry. And I recently had this question asked to me by an attorney. Well, Mr. Carrillo, do you have a problem with people openly carrying firearms? No, I don't have any problems with that at all. As long as it's legal in that state to do so, I don't have any problems with it. And so there's a legal standard here. Now, I don't recommend it. I don't think it's best practice for the average private citizen. And I think we see enough instances of that I can back that up with evidence. But it's not a legal standard. And so if you say, well, wait a minute, simply openly carrying a firearm makes you an aggressor, I would completely disagree. And certainly the law would disagree with that in a state where open carry is legal. So what does all this mean for you? All right. I want you to recognize that in our teaching message at ASP, we do focus on the high standard. We focus on us all being good folks, good, sane, sober, moral, prudent people. In fact, the t-shirts are back in the web store, by the way, this one in royal blue, and on the back, I'm not going to spin around to show you, but it's got the ASP logo real big, and the words to make the ASP logo in there, it says good, sane, sober, moral, and prudent in real little words, again and again and again, repeated to show the ASP logo. It's a pretty cool shirt. Link is in the description. You can pick one up in a multitude of colors. And that's the standard we want folks to aspire to be the very best, because that's the best of who we are. But we also talk about, wait a minute, but the legal standard at the end of the day, this is the bare minimums, right? Here's the bare minimums. Much like in firearms qualifications, if a police officer in Arizona can pass the as-post pistol qualification, they are qualified by the state of Arizona to carry a pistol. And I would not argue otherwise. I would not argue that they shouldn't be allowed to carry a pistol if they can pass that qualification as a police officer. But I sure would encourage them to meet a much higher standard, because on the street on that day, they'll need a higher standard, or they very well could need a higher standard. And this standard was written by lawyers and bean counters and people who haven't been in gunfights. And so your standard that you very well may need to win your gunfight is way up here, whereas this is a liability issue, okay? So legal standard down here. Do you have liability, criminal liability or civil liability? Our standard of good, sane, sober, moral, and prudent, the moral standards can be much higher. Are they the same thing, moral and legal? No, but there is a humongous amount of overlap here, right? Why don't I draw a gun and point it at people? Because it's going to get me charged with aggravated assault to do that in most cases. Why is that? Because threatening the safety of another is immoral. So there is a moral underpinning under the legal standards of almost all of the use of force in all statutory law in America. In everyone? No, there's a few that are kind of malum prohibitum, but as a general rule, the use of force laws, those circles are pretty close to an overlap here. Not quite, but pretty darn close, because what we're talking about here is not harming people don't need harmed. So, in the instances of, say, a justified use of deadly force, if somebody is a deadly threat to you and yours, you have a right to stop that. And so, why did you use deadly force on the decedent, sir? Well, as a general rule, you're not allowed to kill somebody, but the law recognizes the moral imperative that I have the right to protect my own life from being taken from me. And if I am at a legitimate, observed, evidence-based risk of death or great bodily harm, I can stop that threat using up to and including deadly force on the person who is causing that threat to me. They're the initial aggressor, so they're the immoral one who is threatening me with death or great bodily harm. I have the right to stop that even if it causes death or great bodily harm, and they own the immorality of that, and that is the legal standard, and it's built on a moral foundation. So, hope that helps you. Hope that helps you to kind of think through some of those. Out of this, what questions are you left with on the difference between moral and legal use of force? And what other topics like this would you like to see us cover here? Hope you have a great day, everybody.